Early in my legal career, my boss came to me and said, "Gerry, go try this case in Brooklyn. It's a car accident case." Let me share with you why that case never should have been tried. Come join me as I share with you this remarkable story. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. This was very early in my legal career, about 3 months after I had been admitted to practice. Now my boss came to me and says, "Go try this case in Brooklyn. It's an intersection collision." Now remember, at that time I was representing people who were being sued in car accident cases and also in medical malpractice cases. And now my boss said, "Go try this case. It's a question of lights. Each person claims they have the green light." Now that's a physical impossibility unless the traffic light's not working. But he said, "Go try this." So now I'm getting the case ready for trial, I'm prepping, I'm bringing my witness in, and clearly we believe we were correct and that the other driver is absolutely incorrect, the person who claims he was injured. So now I go ahead, pick a jury, and now we're waiting 3 days to get assigned to a trial judge. And the plaintiff's attorney, the injured victim's attorney, comes to me and says, "Listen, we can settle this case, all I need is $1,500 and we're gone." And I said to him, "I can't do that. I have to try this case." He said, $1,500? What's the big deal? Now, this is going back almost 26 years ago. It is a big deal. I'll tell you why. What he didn't know was that the insurance company had a clear agenda. They wanted to send this guy a message that they were not going to go ahead and settle this case for any dollar. Why? Because they believed that he brought a case that didn't have merit. They believe his client really didn't have any injuries. And as a result of that, they weren't going to pay this guy a single dollar. And at the same time, my boss wanted me to get trial experience. And this was the perfect case to do it, where there's no injury, there's no risk of exposure, and at most the jury would ultimately come back with something insignificant. He said, "That's fine. Go try the case, get the experience." So here we are. I spent 3 days picking a jury. I spent 2 weeks preparing the case for trial. And now we go ahead and ultimately we tried the case, and I was successful. What was so important is that when my boss said, "Go try this case," he didn't tell me, "Go ahead, try this case and then settle it." He said, "Go try it." So why do I share this quick tidbit of information with you? I share it with you just to give you an insight and an understanding into what went on so many years ago, yet it still remains vivid in my memory about something that happened that clearly the case never belonged in court, and now it gave me the opportunity, however, to try a case, to get experience, and to have my boss back me up every step of the way. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.